afternoon. I'm Jenny Beth Martin with Tea Party Patriots Action. Thank you for joining today's Lunch Break Live with Tea Party Patriots. In a moment, we'll go to Bill Pasco, who will give us our Washington report. Before we do that, please make sure that you are liking and sharing this live video, whether you're watching it on Facebook, Rumble, or some other means. Make sure that you are sharing it with your friends and your own circle of influence. And finally, while we're going through today, especially while Bill is giving the Washington report, if you have any questions, please feel free to shoot us an email with those questions and we'll do our best to answer them. You can email me directly at jenny.beth@teapartypatriots.org. Again, that's jenny.beth@teapartypatriots.org. And now we're going to Bill Pasco for our Washington report.
Thank you, Jenny Beth. The House and Senate will come back Tuesday. The Senate will stay in session through Thursday, while the House will stay in through Friday. This week in the House, they'll return Tuesday with the first vote set for 6:30 p.m. At that time, the House is scheduled to take up 3 bills under suspension of the rules. On Wednesday and for the balance of the week, the House will consider H.R. 2, the Secure the Border Act of 2023, and H.R. 1163, the Protecting Taxpayers and Victims of Unemployment Fraud Act. Last week in the Senate came back to work on Monday and voted to confirm Anthony DeVos Johnstone to be a U.S. Circuit Judge for the Ninth Circuit Court of Appeals. On Tuesday, the Senate voted to invoke cloture on and then to confirm the nominations of Michael Farbiars and Robert Kirsch, both to be U.S. District Judges for the District of New Jersey. Then the Senate voted to invoke cloture on the nomination of Aurelia Eleta Merchant to be U.S. District Judge for the Eastern District of New York. On Wednesday, the Senate voted to confirm her to that position. Then the Senate voted to invoke cloture on the nomination of Wesley L. Hsu to be U.S. District Judge for the Central District of California. Then the Senate voted to pass H.J. Res. 39, a Congressional Review Act resolution of disapproval of the rules submitted by the Department of Commerce relating to procedures covering suspension of liquidation duties and estimated duties in accord with Presidential Proclamation 10414. This is a significant CRA resolution of disapproval against a Biden administration action. A June 2022 emergency proclamation allows imports of Chinese solar products with no additional tariffs for 2 years, guaranteeing unfair competition for American solar panel manufacturers. Congressman Bill Posey's H.J. Res. 39 would block this rule from going into effect and would thereby reinstate tariffs on solar panel imports. The resolution passed the House by a vote of 221 to 202, with 12 Democrats crossing party lines. It also passed the Senate with a bipartisan vote of 56 to 41. Then the Senate took up S.J. Res. 9, another CRA resolution of disapproval. This one aimed at disapproving the rules submitted by the U.S. Fish and Wildlife Service relating to endangered and threatened wildlife and plants, the lesser prairie chicken, threatened status with Section 4D rule for the northern distinct population segment, and endangered status for the southern distinct population segment. That resolution passed by a vote of 50 to 48. Then the Senate voted to confirm the nomination of Wesley L. Hsu to be the U.S. District Judge for the Central District of California. And then the Senate voted to invoke cloture on the nomination of LaShonda A. Hunt to be U.S. District Judge for the Northern District of Illinois. On Thursday, the Senate voted to confirm her to that position. Then the Senate voted to invoke cloture on the nominations of Colleen Joy Shogan to be the Archivist of the United States and Greta Rao Gupta to be Ambassador at Large for Global Women's Issues. And then they were done. This week in the Senate will return Tuesday with the first vote set for 5:30 p.m. At that time, the Senate will proceed to a roll call vote on cloture on the nomination of L. Feliz Gorordo to be U.S. alternate Executive Director of the International Bank for Reconstruction and Development for a term of 2 years. Then, based on the Majority Leader's cloture filings, I anticipate we may see action on the nomination of Glenna Wright Gallo to be Assistant Secretary for Special Education and Rehabilitation Services at the Department of Education. Walensky resigns. On Friday, Dr. Rochelle Walensky, director of the Centers for Disease Control and Prevention, announced that she would be vacating her position on June 30. Reasonable people everywhere rejoiced. Dr. Walensky's tenure was marked by confusing and contradictory messaging. She was frequently on a different page than the one Dr. Fauci or Surgeon General Vivek Murthy were on, and she seemed never to be on the same page as the majority of the reasonable people of the United States. Now to unions and railways. In the wake of the Norfolk Southern Railway derailment in East Palestine, Ohio, Ohio's two U.S. Senators, Sherrod Brown and J.D. Vance, introduced the Railway Safety Act, which has several reasonable positions in it. Unfortunately, it also has a bad provision in it in its minimum crew size standard. Were the proposal to become law, all freight trains would be required to have a minimum of 2 people on the crew at all times, including a certified conductor and an engineer. This would vastly increase costs for mid-size railways, and for no good reason. It would do little to make railways safer. In fact, there's no evidence that 2-man crews make trains safer. Just ask Norfolk Southern. The train that derailed in East Palestine had a 3-man crew, and yet still found a way to derail despite that. Sherrod Brown is a Democrat who's up for re-election next year, so it's understandable why he'd want to do a favor for unions. But J.D. Vance is a Republican who just got elected to the U.S. Senate and is now serving the first year of his first term, which means he doesn't stand for re-election for another 5 years. So there's no telling what advantage he gets, other than to do a favor for a union. Senate Majority Leader Schumer is making this a top priority this week and working with the Commerce Committee to speed up progress on the bill. Stay tuned. Now to the latest on the Biden crime family saga. 2 weeks ago, we learned that former CIA acting director Michael Morell had testified to a congressional committee that he had written the fabled October 2020 letter signed by 51 former intelligence community professionals declaring that the Hunter Biden laptop story had, quote, all the earmarks of a Russian information operation, end quote, as the result of a conversation he'd had with then Biden campaign aide Antony Blinken, who now serves as the U.S. Secretary of State. Blinken says otherwise. Appearing on Fox News last Monday, interviewed by correspondent Benjamin Hall, Blinken said, quote, with regard to that letter, it wasn't my idea, didn't ask for it, didn't solicit it. And I think that the testimony that the former deputy director of the CIA, Mike Morell, put forward confirms that, end quote. The testimony of Morell, of course, confirms exactly the opposite. Meanwhile, House Oversight Committee Chairman James Comer of Kentucky said yesterday that the Department of Justice should hold off indicting Hunter Biden until after Wednesday of this week, because on Wednesday, Comer plans to make public a report with all sorts of evidence he says he has, showing a pay-to-play bribery scheme involving Joe Biden and what Comer says are many more countries than previously known. Quote, more and more evidence is pointing towards Joe Biden, Comer said. Obviously, Joe Biden was involved in all this despite the fact that he lied to the American people, despite the fact that his press secretary continues to lie about it, end quote. Comer said the report he will release later this week will show that the Biden family received monies from many more countries than previously known, and that the number of Biden family members who benefited from the monies is much larger than previously known. Comer's weekend revelations follow news he released last week, claiming that an FBI whistleblower has told Comer and others that the FBI has a document from the summer of 2020 alleging a pay-to-play bribery scheme in which Joe Biden traded policy favors for money. Stay tuned. Now to illegal immigration. It's taken the House GOP leadership months longer than they had originally anticipated. They had originally planned to have this bill on the House floor within 2 weeks of launching the 117th Congress, but GOP leaders now believe they've lined up all their ducks in a row to pass a major border security and immigration bill. H.R. 2, the Secure the Border Act, will come to the House floor this week. The bill is actually a combination of 2 bills, H.R. 2640, the Border Security and Enforcement Act of 2023, which came out of the Judiciary Committee, and H.R. 2794, the Border Reinforcement Act of 2023, which came out of the Homeland Security Committee. Here's the bullet point take on what's in the two bills. And if you want to read a fuller analysis, you'll have to read this week's Washington Report online, because even the bullet point take is 7 pages long. So I'm going to be cutting here and there. Let's start with H.R. 2640, the Border Security and Enforcement Act of 2023. Title I is Asylum Reform and Border Protection. The background. Unlike the European Union, the United States does not have a safe third country policy that prevents asylum shopping. So applicants for asylum in the United States can travel through multiple countries where they could have sought protection before they reach their preferred destination, the United States. The current low threshold for asylum applicants to claim a credible fear of persecution has created massive backlogs in our immigration courts. When combined with catch and release policies, these backlogs ensure that fraudulent asylum applicants can live and work in the United States for years before finally being denied asylum. From 2014 to 2019, 83% of those who claimed a fear of persecution were found to have a credible fear and were referred to an immigration judge. But only 15% of the asylum cases completed during that period were granted asylum. So, what Title I does. It denies asylum eligibility for aliens who entered or attempted to enter the United States after transiting through at least one country outside of their country of nationality or their last habitual residence, unless the aliens can show they applied for and were denied asylum in one of those countries, they were under 18 or a victim of a severe form of trafficking or slavery and was unable to apply in each transited country, or they transited only through countries that are not parties to the 1951 or 1967 United Nations Protocols on Refugees or the United Nations Convention Against Torture and other cruel, inhuman, or degrading treatment of punishment. It raises the standard of proof for credible fear to more likely than not from significant possibility and allows asylum officers to assess the alien's credibility. It limits asylum to those arriving in the U.S. at ports of entry or brought into the U.S. after being interdicted in international or U.S. waters. It makes ineligible for asylum any alien who has participated in persecution, who has been convicted of any felony or certain misdemeanors, or is otherwise deemed a security concern. It bars granting asylum if the alien could avoid persecution by resettling in a different part of the alien's country of nationality, or if the alien was firmly resettled in another country prior to arriving in the United States. It defines firmly resettled to cover cases where the alien or the alien minor's parent could receive a permanent or indefinitely renewable immigration status, the alien lived without persecution or torture for 1 year or more, or the alien is claiming a fear of persecution in a country other than the alien's country of citizenship. It tightens the asylum process to limit claims based on non-state activity. It mandates a 180-day waiting period before an asylum applicant can apply for an employment authorization document, that's an EAD, and limits such EADs to renewable 6-month periods. It prohibits a determination that an alien is a member of a particular social group when that group is based on generalized violence, a high crime rate in the country of origin, or past or present criminal activity or gang or terrorist group membership, among others. It clarifies that persecution does not include generalized harm or violence in a country, treatment the U.S. regards as unfair, unjust, unlawful, or unconstitutional, intermittent harassment, threats from unidentified entities without effort to carry them out, or non-severe economic harm or property damage. It creates a notice which warns asylum applicants that frivolous asylum claims will result in a permanent bar in immigration benefits, and it establishes expedited asylum procedures for Cubans, Nicaraguans, and Venezuelans. That's Title I. Title II, the Border Safety and Migrant Protection. The background is the Trump administration successfully deterred illegal immigration and fraudulent asylum claims by requiring asylum applicants to wait in Mexico for their asylum applications to be adjudicated. The official name of the Trump Remain in Mexico policy was the Migrant Protection Protocols, MPP. The Biden administration dismantled the MPP program and either released illegal aliens into the United States, that is, catch and release, or granted parole into the United States. The parole designation allowed them to apply immediately for an employment authorization document, the EAD, while illegal aliens who are released into the country with a notice to appear or a notice to report are not entitled to apply for EADs until after they have filed applications for asylum. Now, what Title II does, it makes illegal aliens ineligible for parole or release from custody other than to be returned to their home country or returned to a contiguous country to pursue an asylum claim. And it mandates that DHS must return an illegal alien to a contiguous country, that is the MPP, to await adjudication or remove the alien if DHS is unable to detain the alien during the adjudication, or return the alien to his or her home country. It requires suspension of entry for aliens when DHS cannot comply with detain, return, or removal of aliens. It provides state attorneys general a cause of action to seek injunctive relief from DHS for failure to follow the detain, return, remove, or suspension requirements. Title III is ensuring united families at the border. Here's the background. The Flores Settlement Agreement, initially agreed upon in 1997, was modified in 2015 by Judge Dolly Gee to apply to accompanied as well as unaccompanied minors. This ruling was upheld by the Ninth Circuit after an appeal by the Obama administration. The effect of this ruling was essentially to bar family unit detention. This led to an exponential increase in family unit illegal immigration. In 2018, family units accounted for roughly 161,000 apprehensions, and after COVID, roughly 1 million apprehensions in FY21 and FY22 combined. So, what Title III does, it removes the legal presumption that accompanied minors apprehended at the border cannot be detained. It requires that accompanied minors only be released to parents or legal guardians who are lawfully present in the United States. It requires detention of parents with their alien child. It includes a sense of Congress that these amendments satisfy the modifications of Flores made in 2015 with regards to accompanied minors in custody, and it bars states from requiring detention facilities for family units to be licensed independently by a state to operate. Now, Title IV, Protection of Children. Background. Under current law, unaccompanied alien children, that is UACs, from contiguous countries are treated differently than UACs from non-contiguous countries. While UACs from contiguous countries may be returned immediately, those from non-contiguous countries are required to be transferred to the Department of Health and Human Services, that is HHS, within 72 hours after they're encountered. HHS is required to hold the UACs in the least restrictive setting, ensure access to legal counsel, and locate a sponsor in the United States. These procedural protections for UACs from non-contiguous countries led families to put their children in the hands of the cartels to escort them to the U.S. border, where they could turn themselves in to Border Patrol. UAC apprehensions, which numbered 16,067 in FY 2011, reached what was a record 68,541 in FY 2014. In FY 2021, a record 146,925 were apprehended, only for that record to be broken in FY 2022, when 152,075 were apprehended. For the current fiscal year to date, 70,016 have been apprehended before the anticipated surge in numbers after the end of Title 42 later this week. So, what Title IV does, It treats all UACs the same, regardless of national origin, so that all UACs who are not trafficking victims and who are not in fear of returning to their home country may be returned promptly to be reunited with their families. It requires HHS to obtain relevant information for all sponsors of UACs, including the immigration status of the sponsor. And it requires DHS to initiate removal proceedings on sponsors without lawful status. And it restricts eligibility for special immigrant juvenile, that is SIJ status, to alien minors who cannot be reunified with one parent or legal guardian who is not abusive. Title V, visa overstays penalties. Here's the background. Visa overstays are a significant portion of the illegal immigrant population in the United States and have been trending higher in recent years. In 2016, the Center for Migration Studies estimated that 62% of those here unlawfully had overstayed a visa. Pew Research has said from 2007 to 2017, the share of newly arrived, unauthorized immigrants, those in the U.S. 5 years or less, from regions other than Central America and Mexico, the vast majority of whom are overstays, increased from 37% to 63%. So, what Title V does? It increases the civil penalty for illegal entry and attempts to enter illegally from between $50 and $250 to between $500 and $1,000. It applies the same civil and criminal penalties for illegal entry to temporary non-immigrants who overstay their visa. Currently, visa overstays are not subject to such penalties. Title VI, immigration parole reform. Here's the background. Congress granted the executive branch the power to parole individual aliens only on a case-by-case basis when the case presented urgent humanitarian reasons or significant public benefit on a temporary basis. The executive branch has interpreted this power as providing the ability to grant parole categorically to large classes of aliens, where the executive makes generalized determinations of parole for the class being a broad, significant public benefit or presenting an urgent humanitarian reason. These parole grants include employment authorization document eligibility for grantees. As a result of this interpretation, the executive branch has created a myriad of parole programs, including the Haitian Family Reunification Program, the Cuban Family Reunification Program, the Central American Minor Refugee Parole Program, and Immigrant Military Members and Veterans Initiative, among others. The Biden administration currently is importing 30,000 parolees per month from Venezuela, Nicaragua, Haiti, and Cuba in an effort to deter their illegal entry at the border. So, what Title VI does, it strictly limits parole to a case-by-case basis by prohibiting class-wide eligibility criteria. It allows parole for certain spouses and children of active duty members of the U.S. Armed Forces. It provides parole to residents of Cuba pursuant to the 1994 U.S.-Cuba Joint Communique on Migration. It allows parole eligibility for aliens returned to Mexico pending their removal proceedings solely for the purpose of travel to and from those removal proceedings in the United States. It bars employment authorization for parolees except for the spouses or children of active duty members of the armed forces and nationals from Cuba. It creates a cause of action for individuals, states, and localities to bring civil action for violating the provisions of this act. Title VII, the legal workforce. Here's the background. The primary magnet for illegal immigration is the potential to work in the United States. E-Verify is a free, fast, and accurate internet-based service that allows employers to verify the work authorization of new hires in minutes by entering the information already required on the I-9 form. E-Verify does not create any additional databases. Instead, it simply pings first the Social Security Administration's database, and second, if there is no match in the SSA database, the Department of Homeland Security's database on aliens. So, what Title VII does, it permanently authorizes E-Verify. It requires all employers to screen all new hires through E-Verify within 3 years, with a gradual phase-in based on business size, with agricultural employers having the last compliance date. It increases penalties for knowingly hiring illegal aliens. It requires the Social Security Administration to identify compromised Social Security numbers, that is SSNs, and block their use until contact is established with the legitimate holder of that SSN in order to prevent further identity theft or misuse. It allows parents to lock the SSNs of their children to prevent fraudulent use of minors' numbers. Individuals already can lock their own SSN. Now to H.R. 2794, the Border Reinforcement Act of 2023. It's a somewhat smaller piece of legislation. This bill requires the resumption of border wall construction using funds that were previously appropriated and materials that were previously acquired. It amends the Secure Fence Act to explicitly require physical barriers along at least 900 miles of the border and expedite procedures for construction. It authorizes retention bonuses for Border Patrol and requires Customs and Border Protection to increase to not fewer than 22,000 Border Patrol agents. It requires the Department of Homeland Security, that is DHS, to issue grants under Operation Stone Garden to local law enforcement in border states to assist in border security and explain denials of grant requests to Congress. It requires the CBP to fly no fewer than 110,000 annual flight hours. It requires DHS to update various technologies and submit improved strategies and plans related to border security. It defunds DHS processing of aliens between points of entry and DHS-funded non-governmental organizations, that is NGOs, that facilitate unlawful entry, human trafficking and smuggling, drug trafficking and smuggling, or provide or facilitate the provision of transportation, lodging, or immigration legal services to inadmissible aliens who enter the United States after the date of the enactment. It requires CBP to publish a monthly public report, including detailed encounters broken down by nationality and criminal and terrorist status, known gotaways, drug seizures, deceased aliens, and other statistics collected by CBP that are not currently public. It prohibits COVID-19 vaccine mandates for DHS employees and reinstates those fired as a result of previous COVID-19 vaccine requirements. That bill will see action on the floor this week. It will likely begin debate on Wednesday, and they are trying to have the vote on Thursday, which is May 11th, which is the same day that Title 42 will be lifted. Now to the debt ceiling. The clock is ticking, and we finally have some movement on negotiations over legislation to raise the debt ceiling. Let me reset things to catch you up. President Biden and Senate Majority Leader Chuck Schumer have taken the position that Republicans who control the House of Representatives should vote to raise the debt ceiling without requiring any associated fiscal reforms. In the view of the Democrats, lifting the debt ceiling should be a routine thing, a one-off, and shouldn't be tied to anything else. Republicans think this is hogwash. Republicans in the House and in the Senate think the need to raise the debt ceiling offers a regular chance to address Washington's reckless spending. For months, Biden and Schumer refused to budge, insisting that neither would support tying an increase in the debt ceiling to any fiscal reforms. For months, Republicans in the House and in the Senate said they would not allow the debt ceiling to be increased without accompanying fiscal reforms. The Democrats did not believe House Speaker Kevin McCarthy would be able to pass a bill through the House. They believed he would fail in his attempt to move a bill with nothing but Republican votes, and that he would be forced to watch in horror as a majority composed of all Democrats and just a handful of squishy Republicans worked to pass a bill to increase the debt ceiling without any spending cuts. That plan blew up when McCarthy showed he was able to pass a bill to raise the debt ceiling even as it mandates spending cuts on a 3-to-1 basis. That is, for every dollar it increases the debt ceiling, it cuts spending by $3. The passage of that bill gives McCarthy chips with which to sit at the table. The ball is now in Biden's court. Several days after McCarthy succeeded in passing the debt ceiling bill, Biden invited McCarthy and Schumer, Senate Republican leader Mitch McConnell, and House Democrat leader Hakeem Jeffries to come to the White House Tuesday, tomorrow, to discuss raising the debt ceiling. Democrats are still trying to break off moderate Republicans so they can raise the debt ceiling without having to deal with McCarthy. House Minority Leader Jeffries revealed early last week that House Democrats had introduced a bill months ago that could serve as the vehicle for a discharge petition that would generate signatures from all 213 Democrats and, if possible, 5 House Republicans. But no House Republicans appeared interested in signing on. And on the Senate side, Republicans led by Utah Senator Mike Lee signed a letter, 43 of them, meaning that only 6 Republicans failed to sign, saying they would not vote for an increase in the debt ceiling without spending cuts. The Washington Post's fact checker blew up Biden's false debt ceiling talking points. In a piece published May 3rd, the Post reported, quote, "Within 15 years of the debt ceiling being established in 1939, members of Congress began to use the must-pass debt ceiling increase as leverage to force concessions from the executive branch, according to a 1993 study of the politics of the debt limit. In 1953, Republicans blocked an increase requested by President Dwight D. Eisenhower, also a Republican. The next year, with Democrats in control of the Senate, Harry F. Byrd of Virginia, who then chaired the Senate Finance Committee, was concerned that Eisenhower's goal of building a national highway system would add to the debt accumulated during World War II. Eisenhower asserted that he had moved promptly and vigorously to cut spending, but still needed the debt limit raised to pay outstanding bills. Byrd was not satisfied. He demanded more cuts in exchange for a scaled-back debt limit increase that Eisenhower finally obtained from Congress. In the 1970s, lawmakers, primarily Democrats, began to offer amendments to the debt ceiling that had little to do with government finances, including suspending U.S. bombing in Cambodia or bolstering Social Security, the study said. Continuing with the Washington Post, a pattern soon developed, with lawmakers in each party generally supporting a debt ceiling increase only if the president was from the same party. In 2006, Senator Barack Obama gave a speech on the Senate floor saying he would refuse to approve a debt limit increase requested by a Republican president, George W. Bush, without a plan to reduce the budget deficit. End quote. Moreover, 7 of the last 10 debt limit increases, including, importantly, all 3 that occurred during the Trump administration, were enacted as part of larger fiscal legislation and were not standalone increases, as the White House falsely claims. Meanwhile, Treasury Secretary Janet Yellen announced that because of unexpectedly low revenues flowing into the government, the so-called X date, that is the date beyond which Treasury will lose its magical ability to juggle funds and continue paying bills without an increase in the debt ceiling, has moved up to June 1. If she is to be believed, that means the clock is really ticking. And that's our Washington Report for this week.
Bill, thank you so much for that Washington Report. And before we go to questions, and by the way, if you have any questions, you can email those to Jenny, Jenny.Beth, Jenny.Beth at teapartypatriots.org. Before we go to those questions, let me go over the call to action for the week. So we've got 3 primary calls to action. You can find all of these by going to teapartypatriots.org. The first one is one that we are going to have ongoing for several weeks and probably quite a few months. Supreme Court Justice Clarence Thomas is under severe attack right now, and it seems that the left is just relentlessly attacking him. If they can't expand the court, if they don't have a majority on the court, then they are intent on destroying the people on the court, it seems to me. So what we are doing is urging you to sign a petition supporting Clarence Thomas and also calling your United States senators and telling them to leave Clarence Thomas alone. So that is the first call to action, is to defend Supreme Court Justice Clarence Thomas. The next call to action relates to the border security bill that is passing or moving through the House of Representatives this week. It should be on the floor on Thursday. That is HR2. And so what we want you to do is make phone calls to your Republican, well, even your Democrat, especially your Democrat members of Congress, and urge them to vote for HR2. That is a border security bill. Then after the bill has a vote on Thursday, if it passes the House, which we think that it will, if it passes the House, then please call those members of Congress who voted for the bill and thank them if they are your own member of Congress. We expect that Republicans will vote for it and Democrats will not vote for it. So when the Republicans vote for it, please call and thank them for passing or voting for such a strong border security bill, and make sure that they know that you appreciate it. Politics is oftentimes a game of carrots and sticks. So we kind of use sticks when they're bad and we call and complain, don't do this, stop. Defend Clarence Thomas, like we were just saying, very firm, demands, but also you have to be thankful when they do the right thing. And this is a very strong border security bill. And so when they vote for it, please make sure that you're calling ahead of time to urge them to vote for it, and afterwards you're thanking them. The next call to action is about the debt ceiling. So Republicans have signed on to a letter in the Senate from Senator Mike Lee. The last time that I checked, it was 43 Republican senators who had signed on to this letter. We need to call our Republican senators and our Republican members of the House and thank them for standing strong on the debt ceiling. And then we need to call the Democrat members of the House and the Democrat Senate and senators and remind them that when they are passing a debt ceiling increase, a debt ceiling limit increase, it's like going to the bank and asking for a second mortgage. When you go to the bank and ask for a second mortgage, the bank requires additional things for you. They don't just give it to you carte blanche. You have to negotiate the terms. And since we're the ones who are going to have to pay back the loan and pay back the interest as taxpayers in America, it is important that we are urging that there are at least some cuts in exchange for this debt ceiling increase. And that is the negotiation process that is going on. The Democrats do not have control of both chambers and the White House, so they're going to have to come to the table and negotiate with Republicans. We need to urge them to negotiate with Republicans. We need to tell them that the debt ceiling should only be increased with spending cuts attached to it. Okay, now I'm going to go to a few questions. So let me take a look at those questions. Give me just a minute. I'm looking on my phone, so I'll kind of lift that up so you see what I'm doing. All right, the first question is this. The Senate voted last week not to extend the deadline for ratification of the Equal Rights Amendment. The person is saying they thought conservatives killed the ERA long ago, decades ago. So what was up with that vote, and why was the Equal Rights Amendment a threat again?
Oh, good question. What is the Equal Rights Amendment doing back on the floor of the Senate? Okay, it wasn't the Equal Rights Amendment itself. It was a resolution to extend the deadline for ratification of the Equal Rights Amendment. The Equal Rights Amendment originally passed the House in October of 1971 and passed the Senate in March of 1972. The language of the amendment itself, as many proposed amendments to the Constitution do, the language of the amendment itself included a ratification deadline of 7 years. It said this amendment will become law if it is ratified within 7 years. It'll become part of the Constitution, if it is ratified within 7 years. That expired in 1979. By 1978, 35 of the required 38 states, remember, it takes a 2/3 vote in either House of Congress, and then ratification occurs when 3/4 of the state legislatures, that is 38 in our current environment, when 38 state legislatures ratify the amendment, that's when the amendment is considered ratified and it's added to the Constitution. So as of 1978, 35 of the 38 necessary states had ratified, but it looked like they weren't going to be able to get over the hump. Opposition had appeared. And there were pitched battles in state legislatures in the late 70s. So they got to 35. Congress passed by simple majority vote, both the House and the Senate, with Jimmy Carter as president. A Democrat-controlled House and a Democrat-controlled Senate passed a resolution extending the deadline for ratification by 3 more years. So 7 years became 10 years, and that pushed the ratification deadline into 1982. And that's the first problem, is that resolution pushing the ratification deadline was passed as a simple resolution, not under the terms that would be required for passage of a constitutional amendment. It didn't pass with a 2/3 vote in both houses of the Congress. It only passed by a simple majority vote. Nevertheless, they extended the ratification deadline to 1982. But nobody else ratified, so they were stuck at 35. Then, along the way, 5 different states rescinded their ratification resolutions. That is, they said, we've changed our mind. One of them actually did so. I believe it was South Dakota, though. I probably shouldn't have just said that out loud. But one of the states said that they would rescind it on the date that the extended ratification deadline would expire. Anyway, so you have 35 states who at one time ratified it. Then 5 states come along and say, we've thought better, we de-ratify it. This left it in limbo, but because they hadn't gotten to 38, nobody really cared. There was no controversy to take to a court. There was no dispute because there was no possibility that this was going to be a constitutional amendment added to the Constitution. So it sat there for decades. Until, for some reason, probably because of the rise of the Me Too movement over the last several years, a couple of states took it up again. I can't remember which was the first, but I know that I believe it was either 2018 or 2019, the state of Illinois, their state legislature ratified it, and that became the 37th state, if you don't include the 5 states that rescinded their ratification. And then in 2020, after the 2019 elections in Virginia, where Democrats recaptured control of the lower house of the legislature for the first time in many, many years, and they had a Democratic governor at the time, and they controlled the state Senate. So with control of the lower house of the legislature, somebody said, hey, let's ratify the Equal Rights Amendment. And they did. So the state of Virginia became the 38th state to ratify the Equal Rights Amendment. If you don't pay attention to the fact that 5 states rescinded their ratification, and if you don't pay attention to the fact that the ratification deadline had expired 40 years earlier, almost 40 years earlier, 38 years earlier. That's why last week on the Senate floor, there was, for whatever reason, Chuck Schumer wants to make nice with feminist groups and wants to say, look, we're pushing for the ERA, so we're going to move a resolution to extend the ratification deadline. I don't think it would have had any effect legally. Even if it had passed the Senate, it wouldn't have gone anywhere in the House. It's just, talk about a show vote. That's all that was going on with the vote to extend the ratification deadline for the Equal Rights Amendment in the Senate last week. Nothing but a show vote. Chuck Schumer showing feminist groups that Democrats care about the Equal Rights Amendment.
Bill, thank you so much for answering that question. Let me go to the next question. This person is saying that they read that it is technically unconstitutional for the United States to default on its debt. How does that come into play if nothing gets finalized with the debt ceiling? Bill, why don't you take a shot at that one?
Can President Biden simply ignore the debt ceiling and issue new debt because the Constitution says the validity of the public debt of the United States authorized by law, including debts incurred for payments of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned? No, that's the short answer. Okay, so I've got my pocket copy of the Constitution here. That, if I remember correctly, is the 14th Amendment. Section 4 of the 14th Amendment to the Constitution says, and I quote, "The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But it continues. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. Okay, so what is this constitutional amendment about? The 14th Amendment was passed by the Congress in 1866 and ratified in 1868. What's going on there is you have a Republican-controlled Congress after the Civil War. You'll note the first part of that said that the validity of the credit of the United States shall not be questioned, and it says that all debts assumed by the United States, especially bounties and pensions for service in helping us put down a rebellion or an insurrection, those will not be questioned and those will all be paid. On the other hand, it says any debt incurred in aiding an insurrection or a rebellion, that is, any Confederate debt, not only will not be paid by the federal government or any state government, it outlawed the paying of those debts, and then it declared them illegal and said they are null and void. So what's going on here is the Congress, which at the time was controlled by Republicans. Remember, the 13th Amendment had also just been passed. The 13th Amendment allowed, the 13th Amendment emancipated the slaves and decreed that slavery was outlawed and that they were now to be considered citizens equal to all the other citizens of the United States. And what did that mean politically? That meant that, believe it or not, when the southern states came back into the Union, remember they had seceded, they had left the Union for the war. Now, as part of Reconstruction, they are readmitted into the Union legally. Their delegations were going to be bigger. They were going to have more representation in the House of Representatives. Their numbers in the Senate wouldn't change because the number of senators is always fixed. There's 2 senators for every state, regardless of how big the state is. You get 2 senators. But the size of your delegation in the House is a direct function of how large is the state's population. And you remember earlier, in the original language of the Constitution, slaves were considered, they were to be counted as 3/5 of a person. And that was done by Northerners who were worried that the Southerners had so many slaves that they would overwhelm the Northerners in the House of Representatives. So the original compromise, believe it or not, pushed by the Northerners, said we will count a slave as 3/5 of a person for purposes of apportionment and counting up how many people you have in your state for purposes of representation in the House of Representatives. Well, now they're going to go from being counted as 3/5 of a person to being counted as a whole person. And when you go from 3/5 to 100%, you're increasing the size of the delegation to the extent that you have slaves, you're increasing the size of the delegation by 60%. And what they were worried about, the Republicans who controlled the Congress, they were worried that, okay, we've passed a law that says we're going to assume that these debts are valid and they shall not be questioned. That is, the debts that were incurred to fight the war, the Union debts, were not going to be questioned. And the Confederate debts are going to be null and void. And if you are an arms manufacturer and you sold rifles to the Confederate Army on credit, sorry, you're out of luck. You're never going to get that money paid. What they were worried about was that when the House delegations were changed to reflect the additional population, they were worried that the South was going to overwhelm the North in terms of representation in the House of Representatives, and they were worried that the Democrats would then be in control and would repeal the laws saying that the Union debts will be good, will be assumed and paid by the federal government of the United States, and the Confederate debts will not be. They were worried that Southern representatives would control the House of Representatives because of their number, and that they would repeal that law. So while they had the strength, they pushed through a constitutional amendment, knowing that a constitutional amendment can't be repealed very simply. That's why the 14th Amendment includes that section about public debt. Now, that's the background. The question now is, it says the credit of the United States shall not be questioned. The question is, can the president rely on that line in the Constitution to simply issue new debt, even if the Congress has a law in place, even if there's a law in place that says the debt is capped right here? Can he continue to issue debt above and beyond that simply because the Constitution includes a line that says the public credit of the United States shall not be questioned? And I got to tell you, there is no clear answer on this. There are constitutional scholars who believe, yes, that's exactly what it means. They believe that there's a number of constitutional problems here. Obviously, the Constitution, elsewhere in the Constitution grants to the Congress the power of the purse. That is, the power to levy taxes, the power to raise taxes, the power to appropriate funds, the power to spend money, the power to borrow money. These are all found in Article 1, which is the article that establishes the legislative powers of the government of the United States. All of that is found in Article 1. It's the Congress that has the power to borrow money, not the president. So that's a problem. You run into a constitutional conflict there. But these particular constitutional scholars say, okay, but that would be doing less damage than the damage that would be done if the full faith and credit of the United States were to be questioned by not paying a bill, by going into default. Other constitutional scholars say, no, it doesn't mean that. It doesn't mean that at all. And here's where I come down. While the constitutional scholars can go back and forth, it's never been tested in court. That's one of the reasons that we have to say it's an open question, because it's a principle, it's a proposition that has never been challenged. But here's the way I look at it. To challenge the full faith and credit of the United States, you're talking about bondholders not being paid. You're not talking about Social Security recipients being paid. If a Social Security recipient doesn't get paid on time, if a veteran's benefit check doesn't go out on time, if an FBI agent or a Border Patrol agent misses a paycheck because the federal government of the United States doesn't have money in its bank account, that does not affect the full faith and credit of the United States as it's defined for purposes of this constitutional amendment. In that context, what we mean by the full faith and credit of the United States is, do the bondholders get paid? Do the people who loaned money to the United States government get paid? This is like paying your credit card. You never, ever miss your mortgage payment. That's the first thing you pay. The mortgage lender gets paid before you pay your gas bill or your electricity bill. The mortgage gets paid first because you need to keep your credit rating good. Well, it's the same thing with bondholders. When it comes to paying and whether or not the full faith and credit of the United States government will maintain itself intact, that's wholly a function of, do bondholders get paid? And there is plenty enough money coming in on a monthly basis to pay the outstanding credit obligations. Bondholders can continue to get paid. So all that requires is the Secretary of the Treasury to prioritize payment to the bondholders. She's got hundreds, literally, Janet Yellen has hundreds of billions of dollars coming into the federal Treasury every month. The problem is that we spend more than hundreds of billions of dollars. We spend a little more than $100 billion a month more than we have coming in. That's how we create this debt, because we spend more than we take in. So while she doesn't have enough money to pay all the bills, she certainly has enough money to pay the bondholders. And that would allow her to maintain the full faith and credit of the United States government without having to have the president issue new debt in violation of Article 1 of the Constitution. So While it's an interesting legal question, politically, it's irrelevant because we don't ever need to go there. Even if the Congress does not raise the debt ceiling, the Secretary of the Treasury has enough money coming in to pay the bondholders and maintain the full faith and credit of the United States government. That's my answer there.
Thank you, Bill, so much for answering that question about the debt ceiling. All right, let me go back through the call to action one more time, very, very briefly. The first one is to defend Clarence Thomas. The second one is to urge the House to pass H.R. 2. And when they do, if they do on Thursday, thank the Republican members who vote for it if it is a member, if that member represents you. And then the third thing is to urge the Republicans to stand strong on demanding cuts associated with the debt ceiling. If you have not done so already, please be sure to check out my new podcast. It comes out, we're doing one episode a week. This week's episode will be with Sheriff Joe Martinez, who is the sheriff in Valverde, Texas, in Del Rio, Texas. He is a border sheriff, and we interview him about the upcoming expiration of Title 42 and what he thinks is going to happen with that. So be sure to tune in this week for the podcast interview with Sheriff Martinez. And if you've missed any of the ones in the past, you can check them out. If you go to go to teapartypatriots.org, we have a link so you can hear and see all of those podcasts or watch the video associated with it. We'll see you again next week for our next Lunch Break Live with Tea Party Patriots. And if you have any questions between now and then, feel free to shoot me an email at jenny.beth@teapartypatriots.org. Thank you so much.